ACCA Corporate and Business Law, Chapter 6, Types of Business Organization. From this chapter onward, we will study everything about the company law, business law, or company law. Types of business organization. There are mainly three types of business organization. Sole tradership, partnership, and limited liability company. We have studied these types of organization in very much detail in BT, even in financial accounting paper as well. Sole tradership is a business of single owner. He is the single investor. He is enjoying all the profit. He will be liable for all the losses. He is running business by himself. Either he can run by himself or he can employ some helper. But the issue with the sole trader business is that the owner's liability is unlimited. In case of losses, his personal property will be used to pay off debt of the business. Partnership is a business where two or more persons invested money together. They are running the business. They are sharing profit as per agreed ratio. But the loss will be shared as per the investment. Profit will be shared as per agreed ratio. But the loss as per the investment. And in partnership business, even partner's liability is unlimited. And in case of loss, their personal property can be used to pay debt of the business. Limited liability company is a separate legal entity, artificial person in a society. The owner of the company are called shareholder. The management of the company are called directors, and owners, shareholder having limited liability. Limited liability mean up to the amount of investment their personal property will not be used to pay debt of the business. In this chapter, we need to study detail about partnership. Regarding company, there are so many chapters. So, types of business organization. Sole trader, practitioner. The owner is the business, owns the asset, and is liable for all the debts. No legal formalities are required to set up as a sole trader business, while for a company, there are some legal requirements you need to meet. This form of business is inappropriate for large business, means small business. One single person can manage, but for large, you need some expert people or those involved in a degree of risk. General partnership defined by Partnership Act 1890. Partnership is defined by Partnership Act 1890 as a relationship which subsists between persons carrying on a business in common with a view of profit. How these relationship will work, we're gonna study later on. Limited partnership is a partnership in which there are some partner who are having limited liability up to the amount of investment. But there should be at least one partner who is having unlimited liability. So if any of the partner is having a limited liability up to the amount of investment, in case of losses, his personal property will not be used. So that partnership business will be called limited partnership, not limited liability partnership. There is a difference between limited partnership and limited liability partnership. Limited liability partnership LLP is a partnership business that is registered as LLP. in which partner's liability is limited up to the amount of investment only. While limited partnership is a partnership business in which some of the partners are having limited liability and some are at least one should be having unlimited liability. Can you understand this? Limited partnership and limited liability partnership. And limited partnership formed under the Limited Partnership Act 1907, while limited liability partnership an artificial legal entity where the liability of the members is limited to the amount of capital they have agreed to contribute. While company is a corporation, separate legal entity, artificial person in a society that we will study in more detail in next chapter. The rest of this chapter will focus on partnership. What is partnership? A partnership is a relationship which subsists between two or more persons carrying on a business in common with a view to profit. And this is formed, registered as per Partnership Act 1890. A partnership can be a small operation or as with some large firms of solicitors, mean lawyers and accountants, auditors, partnerships with several hundred partners. There are different types of partners. General partners, who is involved in running of the business, is called general partner. Sleeping partner, who have just invested the money and is not involved in the running of the business, who will be called sleeping partners. Takes no active part in running of the business, however, is jointly and severely liable for the debt and contracts of the business. Profit loss he will share, but he is not involved in running of the business. Limited partners in a limited partnership contributes a specific amount of capital only. I mean, there are some partners whose liability is limited. Liability limited to their amount and cannot take part in the management of the firm. But there should be at least one partner who is having unlimited liability. Salaried partner, who is receiving fixed salary as well because he is involved in running of the business. So will receive a fixed amount in income, not a real partner, unless they also receive a share of profit. In the partner, like a normal partner, but he is also receiving salary because he is performing some extra work. So he will be called salaried partner. There are three types of partnership: general or ordinary partnership in normal partnership business that is formed as per Partnership Act 1890, where all the partners are having unlimited liability. It's not necessary everybody is involved in running of the business. Limited partnership that is governed by Limited Partnership Act 1907. We're gonna discuss its detail later on. And limited liability partnership governed by Limited Liability Partnership Act 2000, legally separate from its member. It's like company that we will study in next chapter. Characteristics of normal partnership, general or ordinary partnership. When we use the term partnership, this means normal partnership where partners are having unlimited liability. In order for a partnership to exist, a business must be carried on with a view to profit. In partnership, profit making organization. Sole trader, profit making. Joint stock company, profit making. This means that the persons involved in the partnership intend the business to yield a profit, earn a profit, and they are all entitled to share in that profit. The following do not necessarily create partnership, mean these are not partnership business. Joint ownership of property. Three persons jointly made investment in the property. This is not partnership, this is joint ownership. The sharing of gross return. Mean 3-4 people bought an asset and they are using that asset and getting benefit, that is not partnership. The sharing of expense, 3, 4 people contributing towards one expense, again for the use of any of the asset. So that is not partnership. Partnership is a business where you're performing business activities to generate profit and you're sharing that profit with each other. There is a case cost versus Q. C agreed with M that M would put on a play at C's theater. Means C is having a theater in building. M will play, perform different events on C's theater. C was to have 60% and M 40% of the gross box office receipt. Whatever the will be theater income, play income, 60% C will be receiving and 40% M. C paid the expenses of running the theater and M paid the expenses of putting on the play. Theater relating expenses C will bear and play related all expenses. If you need some actor, who will bear M. During a performance, the claimant Cox, who was in audience, was accidentally shot by one of the actors. They were using some guns. So one person was sitting in the audience, he was shot. The claimant sued C because that theater belongs to whom? C. But who is responsible for play? M. The claimant sued C, alleging that C was M's partner and was jointly liable with M. But court decided C was not M's partner because they merely shared gross box office receipt. They haven't signed a partnership business like we are the partner, we are making this investment and we will share profit like this. The partnership begins as soon as the partners start their business activities. Partnership business will be started where partner have started business activities. Even that business is registered still or not. The actual agreement may not be made earlier or later than that date. And it is better when you are starting business activities, you need to form agreement, partnership agreement. No formalities are required to form general partnership. No documentation and no registration. The reason for this is that the Partnership Act 1890 applies to every partnership, whether written or oral. Many of the Act's provisions apply unless they are excluded by a partnership agreement. The Partnership Act 1890 provides that partners shall share profit equally. But in case where partners contribute different amounts of capital, this may not be appropriate and partner will need to agree specific profit. Profit will be shared as per agreed ratio within their partnership agreement. The partnership agreement is a contract. Like any contract, it may be expressed, oral, written, or by deed, or implied. The partners are contractually bound by the terms they have agreed, even if they conflict with the Partnership Act 1890. Whatever the terms they have agreed with each other, they are bound. Limited partnership under Limited Partnership Act what is limited partnership? Not limited liability, limited partnership. A limited partnership is a partnership in which the liability of one or more partner is limited to their capital contribution. Not all. One or. If all, then limited liability partnership LLP. A limited partnership must fulfill the following condition. There must be at least one partner with unlimited liability. The partnership must be registered with the Registrar of Companies as a limited partnership under Limited Partnership Act 1907, not 1890. Limited partners may not participate in the management of the business. If they do, they forfeit their limited liability, mean then their limited liability will be foregone. Then their liability will be unlimited. Mean limited partner is like sleeping partner. Unlimited partner has no power to bind the firm to contract because he's not involved in day-to-day operations, so he cannot sign contract with customer. I.e., unlike the unlimited partner, they are not an agent of the firm. Limited partner is not agent of the firm. Normal partner is agent of the partnership business. All the normal partners are agent of partnership business and agent of other partners as well. I mean, they are working on behalf of other partners as well as partnership business. Authority of partner. What authority partners are having? Partners are having authority according to agency relationship. Each partner is agent of other partner as well as partnership business. So they are having authority to perform transaction on behalf of other partners as well as partnership business. So partners are agent of partnership as well as other partners. So when entering into a contract to carry out the business, each partner is acting as an agent of all the partners. The principles of agency covered in Chapter 5 are applicable to partners and their authority. The express authority of a partner is set out in the partnership agreement. The implied authority is set out in Partnership Agreement Act 1890. A partner may have apparent authority where the other partners have allowed the partner to enter into certain transaction such that the partner has been told out as having the authority to enter into those transactions. If a partner is performing transaction with a third party on behalf of other partner or partnership business, and if partners have decided no, he is not our part agent, but he is still performing those transactions with the customer. And if customer lost anything, they can sue all the partner because he is assuming apparent authority. If that partner is not your agent now, you need to communicate with the customer. Partnership Act 1890 states that every partner is the agent of the firm and the other partners. This means that each partner has the power to bind all partners to business transaction entered into which their express, implied, or apparent authority. The general public will assume he is agent of all the partners as well as partnership business. Implied authority under Section 5, every partner is presumed to have the implied authority to sell the firm's good. And he can perform transaction with the customer, sell goods to customer on behalf of partnership, buy goods necessary for are usually employed in the business. Mean he can appoint people, receive a payment of debt due to the firm. Mean from customer he can receive payments, engage employees. He can assign duties to employees, employ a solicitor lawyer to act for the firm in defense of a claim in the pursuance of a debt. Mean to recover debt from a customer, if they need solicitor, a partner can appoint a solicitor and other partner have to approve the payment of the solicitor. They cannot say, no, you have appointed the solicitor, you pay the payment. No, he's acting on behalf of all of the partners. Trading partnerships. Trading means buying and selling of goods. The above implied powers apply to both trading and non-trading partnership. Partners in trading partnership have additional powers such as borrow money as well. Mean he can borrow money from bank on behalf of other partners. This means if a bank is giving money to any of the partnership business, though only one partner having negotiation with the bank, all partner will be liable for paying back that loan. In order to be acting within their implied or apparent authority, the individual partner must be acting within the usual scope of partner's power in the particular business concern. And there is a case, Mercantile Credit Company versus Garrett. Credit Company like bank. P&G, mean Garrett, entered into a partnership to let lock up garages and repair cars. P ran the business and G was a sleeping partner. The partnership agreement expressly stated that the firm would not buy and sell cars. They will just repair the cars. P sold a car to a finance company M. M sued G to recover the 700 pound because that car was defective. So they returned the car and they asked for 700 damages. So M sued G because he assumed G and P are partner. M sued G to recover the 700 pound which it had paid to P for the car. G denied liability, claiming that P, when selling the car, had been acting outside the agreed limits of the firm's business, and therefore P had no actual or apparent authority to make the contract. Evidence was given that other garage business of the type carried on by P and G did deal in cars. While other garage businesses were dealing in cars. So what was the court decision? The test of what is the firm's business is not what the partner agreed it should be. Though they agreed we will not sell car, but garage business even sell car. But what it appears to be outside world to be. Under that test, P appear to M to be carrying on business of a kind carried on by such a firm. So this contract was within the apparent authority of P and therefore the contract was binding on G. Because P was partner, he was agent of P as well as business. Liability for partnership debts. Who is liable for partnership debts? All the partners. Is there liability in contract? The firm is liable for contracts made by a partner if they were acting within their express, implied, or apparent authority. The firm is not bound by the action of a partner if the third party knows the partner has no authority. I mean, knowingly, if third party have signed any contract with any of the person, knowingly he is not partner of that business, the partnership business will not be liable for third party. The partner has no authority and the third party does not know or believe them to be a partner. I mean, a person is not a partner of partnership, but he is saying to the outer world, I am the partner of this business. Who will be liable in case of losses? That person, not partnership business, because he is not a partner. Holding out. If a person saying I'm the partner, I'm the partner, I'm the partner, but he's in fact is not the partner, who will be liable for third party damages? That person, not the partnership. Every person who by their words or conduct represent themselves or knowingly allows themselves to be represented as a partner is liable as they are a partner to anyone who thereby gives credit to the firm. And if any person is saying, I'm a partner of that business, I'm a partner of that business, but actually he's not. So if third party suffered any loss due to transaction with that person, who will be liable? That person, they cannot sue partnership. Martin versus Gray. G went to Cornwall to discuss the possibility of investing in a tin mine belonging to X. So G asked Cornwall, there is an opportunity to invest in a tin mine. Who is having that mine? X. Nothing came of the discussion, but while G was in Cornwall, he was introduced by X to M as a gentleman down from the London, a man of capital. There were three persons, G, X, and M. So G went to Cornwall to discuss the possibility of investing in a tin mine belonging to X. Nothing came out of the discussion, but while G was in Cornwall, he was introduced by X to M. In X introduced G to M, saying that M is a gentleman down from London, a man of capital. He knows about investment, how to make a profit from investment. He is an expert person. Who is saying? X is saying. M later gave X credit, believing he was in partnership with G. And he was saying in his presence, and they both were smiling. So he assumed they are in partnership, and he suffered some losses. And he sued both. Court decided the introduction amounted to a representation that G was in partnership with X, and so G was liable for the debt incurred subsequent to the introduction. He should have made the true position clear by correcting the impression. Because if you are saying he is a gentleman, man of capital from London, mean I am also investing, you should also invest. This means he believe he is your partner. Liability in tort. What was tort? Civil claim. What was vicarious liability? On behalf of others. So if a partner is performing some transaction with third party, so on behalf of that partner, who will be liable? All partners as well as partnership business. The concept of vicarious liability was discussed in chapter 4 in the context of the employer-employee relationship. The same principle apply in the context of partnership. Where a tort is committed during the ordinary course of the partnership business or by a partner acting with the authority of the other partners, the partners are jointly and severely liable to the person who has suffered loss. All partners are jointly and severely liable for the loss of partnership business. Even that loss is occurred due to wrong act of single partner. Misapplication of money or property. If any of the partner misuse the partnership property or money, the partnership is liable to make good the loss where a third party's money or property is misapplied. Even though due to bad act of one partner, all partner will be liable for it. After being received by a partner within their express, implied, or apparent authority, or while it is in the custody of the firm, such as in the partnership bank account. If from the partnership business, any of the employees stolen some money that was relating to any of the customer, who's liable? All the partners. Which partners are liable? According to general rule, all partners are equally and severely liable. So every partner is jointly and severely liable for the debt and contracts of the business. Outsider can sue one partner alone or the firm. Mean all partner. The Civil Liability Act 1978 provides that a judgment against one partner does not bar a subsequent action against the other partner. And if court has decided against one partner, so that is against complete partnership business. New partner. A new partner is not personally liable for the debts incurred before he became a partner. In previous debt, new partner will not be liable. He will be liable for the debts after he joined as a partner. Retiring partner will be liable for all the past debt, even if he leave the partnership business. Not for future debt, for past in his present debt, he will be liable. So a retiring partner remains liable for any debt incurred while they were a partner. If no notice of retirement is given, the firm continues to be bound by their action as they are still being held out as a partner. If you are removing any partner from the partnership, you need to communicate to general public he is not our partner. If you fail to communicate to the general public and he performed some transaction with the previous party, third party customer, firm will be liable. Though while performing the transaction, he was dismissed as a partner. But if you fail to communicate, public will assume he is your partner. Change in partnership, where a third party deals with a partnership after a change in partnership, mean any of the partner removed, and with the retiring partner, third party signed some contract and suffered losses. All of the partners of the old firm are still treated as partner until the third party received notice of the change. Previous customers require actual notice, and third parties who were not existing customer can be notified by a notice in the Gazette, London Gazette. Partnership Act 1890, this is known as constructive notice. London Gazette means there is some kind of journal or newspaper where you need to put a notice, mean advertise. This person is not our partner. Notification must take place prior to retirement if the retiring partner is to avoid liability for contracts entered into their retirement. If that notice is not provided for the Retiring Partner Act, partnership business will be liable. Innovation. What is innovation? Instead, the creditor agree with the outgoing, continuing, or incoming partner that liability for an existing debt will be that of the continuing and incoming partner. Mean, if any of the partner leaving the partnership business, he will be liable for the previous debts. But if partners are selling their business to new partners, and if new partners agree, okay, we will be liable for previous debts, then those retiring partners, leaving partners will be excluded from the liability. Thus, the liability of the outgoing partner is removed and the incoming partner becomes liable for the debt even though it was incurred before he or she became a partner. Innovation instead. Normally, incoming partner will be liable for the debt after he joined as a partner. Retiring partner will be liable for the debt before he retired as a partner. Innovation instead. If they agree with each other, no retiring partner will not be liable, only new partner will be liable even for the previous debt, then this will be accepted. Indemnity. The continuing and incoming partners may agree to indemnify the outgoing partner against debt incurred pre and or post retirement. Release. Indemnity mean release. Mean if any of the partner is retiring, the existing partner can release him from the previous debt as well if they agree with each other. Mean he will not be liable for previous debt when he was part. Resolution mean when partnership business will dissolve mean end. Dissolution could be with the court order or without court order. Mean court can order to dissolve the partnership business if there is a court case due to some dispute between partners. Our partnership business become end automatically. That is without court order. So the partnership will automatically end in the following situation. The expiry of a fixed term or the completion of a specific enterprise when partnership business was formed for 5 years. It was written agreement. We need to run this business for 5 years. After 5 years, there will be no partnership. So after completion of 5 years, partnership business will automatically end without court order. One of the partner give notice unless the partnership agreement exclude this right. If any of the partner want to leave partnership, the partnership business will end. Now, if the existing partner want to continue partnership, they need to sign a new partnership agreement with each other. And this right is normally given to all the partner. If there is a term in the partnership agreement, no partner can leave the partnership without consent of other, then partnership will not dissolve. Death or bankruptcy of a partner, the partnership business will automatically end. The partnership agreement will usually make provision for the partnership to continue if a partner should die. If there is a term, condition, then it will continue. The representative of deceased partner will become partner. Where continuation of the partnership would be illegal. Mean you are performing business operations that are void, that are illegal. And if you continue the business, there will be fines, penalties. That will not be legal transactions. So partnership business will automatically end. So when partnership business automatically end, expiry of a fixed time period for the business, notice of any of the partner to leave, death or bankruptcy of any of the partner, continuing partnership would be illegal. There is a court case. Hudgel Yeats and Company versus WhatsApp. HY Company versus WhatsApp. Practicing solicitors, lawyers are required by law to have a practicing certificate. Without certificate, you cannot run legal firm. And that certificate is posed for 1 year. This means every year you need to renew it by paying a fee to the body. So there was a law like lawyer firm can be run through a practicing certificate mean license. One of the partner in a firm of solicitor forgot to renew his certificate license, which meant that it was illegal for him to practice. So the failure to renew the practicing certificate brought the partnership to an end automatically, although a new partnership continued between the other two members. But previous between three members automatically ends. Because it is illegal to run partnership without having a solicitor license. Partnership business can be resolved by court order. If there are dispute between partner, there is court case going on. So court can order to dissolve the partner. So the court can bring partnership to an end if any of the following situation. Partner has a mental disorder or permanently incapable. So court will order the partnership business to end. Existing partner have to form new partnership. Partners engage in activity prejudicial to the business. Prejudicial means against the business. Mean one of the partner has formed an other competitor business. So in that case, if the existing partner have filed a suit in the court, so court will order to dissolve this partnership. Partner will willfully or persistently breach the partnership agreement, mean they are not working as per partnership agreement, mean they are working, performing transaction above authority, mean they are not working as per agreement. And one of the partner has put a case in the court. If they are not working as per agreement, court will order to dissolve the partnership because now they cannot run the business as a partner. Partner conduct themselves in a way that it is no longer reasonably practicable for the other to carry on business with them. Again, competitor business you have started. Business can only be carried out at a loss if business is incurring losses. And third parties have sued the partnership business for damages. And court will see business is unable to gain profit to pay off the debt. Court will order to dissolve the partnership business. Now partners have to pay the debts. It is just and equitable to do so. Mean if you don't dissolve the business, there will be no benefit. So court can order dissolve the business. So when court can order this mental capacity of incapacity of the partner, partners are working against the business, partners are willfully breaching the partnership agreement, partner conduct that is not in favor of the business, business is in losses, and it is just and equitable to do so, mean dissolving the business is better than running it. Distribution of asset, in if partnership is dissolved, how the asset will be distributed. First, the debt holder will be paid off by selling asset. If there are remaining asset, that partner can distribute with each other as per investment ratio. But if assets are lesser, debts are more, partner need to contribute from their personal profit. In the event of dissolution of the asset of partnership will be used to pay off the debt of partnership. As a partnership does not have the advantage of limited liability status, if the proceed of the sale of asset does not cover the debt, in asset value is less than the debt, then partner's personal property will be called upon to make up the shortfall. The proceed from the sale of asset will be applied in the following order. Mean by selling the asset, the amount first will be paying debt to the outsider, paying the partners any advance they made to the firm beyond their capital contribution, like if any of the partner paid or given a loan to the business, so that loan will be paid. to the partner, paying the capital contribution of the partner and remaining according to their investment ratio will be distributed. If there is a residual remaining, this will be divided between the partner in the same proportion in which they share the profit of the partnership. In the event that the assets are insufficient to meet the debt of the outsider, then profit held back from previous year or partner capital will be used to make good the shortfall. If these are also insufficient, then partners will individually contribute in the proportion to which they share the profit. As per profit sharing, they will pay the debt. What is LL? Limited liability partnership that is registered as limited liability partnership means partner's liability will be limited up to the amount of investment on. A limited liability partnership is corporate body which combines the feature of traditional partnership as well as company. LLP are covered in the next chapter once we have covered the characteristics of the company. That's it for today. See you.